records, or we have Sunshine Notices that's sponsoring this event. They do notice to owners. I'm sure they can help you out as well with looking at the public records to see who owns the property. But again, this begins at the time of contracting. So if that person's name isn't on the contract, you may have problems leaning that other person's interest. Spouses. All right. Me and my wife, we own a piece of property. You only contract with me. My wife knows nothing about anything. Well, how does it work then? Here's the exception. There's actually a statute out there, I believe it's 713.12. And they actually say that the spouse, the contracting spouse, is deemed to be the agent of the other non-contracting spouse. So whether she likes it or not, she just got sucked in. Except, this is the only way, and I've never seen this really happen. There is a way for her to get out of being responsible. If her and I are separated and living apart, she's not going to be responsible. So that's why when I file my lawsuit, I say Randall Gilbert and Heather Gilbert are living together and are not separated at the time of contracting. I put that in as an allegation because I want to know I want to get rid of that that potential defense. The other way is that the spouse may record an objection within 10 days of learning about the contract and then gives it to the contractor. Never seen this happen. Could it happen? Sure, it could happen. I've never seen it happen. Next one is very important. We're going to be talking about landlords and tenants now. Going back to the definition. The definition, again, is about what a lien extends to, only to the right, title, and interest of the person who contracts at the commencement, or is thereafter acquired. A landlord and a tenant. Does a tenant have a right to ownership of that property? No, you know that. So, what do you get? This is what happens. You only get a lien on their interest in the property. So, for instance, if I'm going to be foreclosing on the lien, I'm going to be foreclosing on whatever interest that tenant has in the property. Now, this is useful if you're dealing with a major anchor tenant. Not very useful if you're dealing with somebody who may not be there tomorrow or may not be there 2 years from now. So, what do? You try to hook in the landlord. You try to hook in the landlord by giving a notice to owner. Because remember, you're not dealing technically with the owner. You give a notice to owner to the landlord saying, hey, landlord, you're the owner of the property. I'm dealing and I'm working on this project. I'm improving your place which you own, but you're leasing it to somebody else. Here's a notice to owner just so you know that if I don't get paid, I may be looking to you in order to pay me. Okay? Well, there's still a way, there's two ways, there's a way for a landlord to exempt himself or herself from any liability. And how do they do that? And I'm talking about with respect to liens. This is, again, something that the lien notice companies do. They look in the public records for you to find out whether or not there's a short form of the lease that the landlord can record in the public records. In other words, let's assume you're doing work in Broward, Palm Beach County, doesn't matter. Whatever county it is that the property is located, you look in the public records. And you see, did the landlord record the paragraph of the lease that talks about liens? In other words, what it'll say is that, let's assume that it's this building right here. There may be 25 units in here. The landlord owns this building, but he leases it out to 25 different people, 25 different tenants. The landlord can record in the public record saying, this property located at whatever this address is, whatever the legal description is, any units in here all have a lease, and every lease contains this identical provision, which says that contractors, if you're thinking about leaning this project, you're not going to because you're going to have to look directly to the tenant. And it works to that effect. In other words, it tells you, it puts you on constructive notice. You may not have actually seen it, but it's in the public record, so you're deemed to know about it, because it's your fault if you didn't look for it, that, hey, you may have to be looking just to the tenant. So just be aware of that. If that becomes the case and you find out that, hey, wait a minute, there's a short form lease out there and I'm doing some major work, $100,000, I may not have lien rights because this person may be gone tomorrow. You may want to seriously think about getting a personally guarantee. You may want to think about having the tenants put up a bond to make sure that you get paid, because you may have some significant concerns. You may just be, I'm not saying you don't have any rights, I'm just saying you're not going to have perfected lien rights possibly. For instance, you can still sue the tenant for breach of contract, or unjust enrichment, or quantum meruit, which means the reasonable value of the services that you've rendered, but you're not going to have a lien unless we go through the process. So now, you went ahead and you looked in the public records and you see the short form lease. It's recorded, it says that that contractor, you're not going to have any lien rights. So what do you do? Well, there's another exception, and this is the pith of the lease exception. No, I didn't stutter, that's the way it's pronounced, P-I-T-H, pith of the lease, which means if in the lease agreement between the landlord and the tenant, the construction of improvements is an integral part of that agreement, I can still go after that landlord. I don't care that you put that short form lease in there, disclaiming any liability. I can still go after you, landlord. Why? I'm going to give you an example. I was recently representing an electrical contractor. This was a $6 million project. The electrical contractor only had about a $100,000 nut in this case, but we did a request for production of documents. I said, I want to see the lease agreement. The tenant, forget it, was gone. They had no money. They had everybody in the world going after the tenant. I didn't think we would ever get a dime out of the tenant. So we're going after the landlord now. And in fact, it was Sunshine Notices that actually happened to do the notice to owner on that one. They did the notice to owner. That's good. I can now have a potential pocket to go after. I'm going to look to the landlord. Damn it. They got a short form lease in there. It says I have no lien rights against the landlord. I got one more way to go after that landlord. I got a copy of the lease. The lease agreement says specifically in there, tenant, here's everything that you're going to be doing. Here's all the construction. Here's the mechanical. Here's the air conditioning. Here's the plumbing. Here's the electrical. It's specified all the construction that this electrical contract, that all the contractors had to do. In other words, landlord, you can't disclaim any liability to the contractors by saying, I'm not going to be subject to any liens, but at the same time telling the tenant you have to do construction in the unit. So in that case, we settled. We got the contractor took about a $5,000 haircut, which he was very happy with, as opposed to a $100,000 haircut. Why? Because the agreement fit within the exception to the exception, which is the pith of the lease. Contracts with condominium unit owners. We're now moving on to another subject. Condo unit owners. It's not much different than a regular owner. You lien the unit. That's what it is. Now let's talk about condominium associations. That's a little bit more difficult. Condominium associations now, they're actually governed by a different statute. Condominiums, they have their own chapter, 718. Construction liens are under 713. Now, the lien rights are split depending upon where you come in during the course of a condominium. Let's assume that this is a condominium that's going up. They haven't yet recorded their declaration of condominium. What happens? You can lien for everything. If you put a lien on the project because you've done some work, you get a lien on the common elements, you get a lien on every single unit in there. You get a lien on the entire building, and all of the common elements 100%. What happens, which is most scenarios, you're doing work for a condominium that's been established for years. They have their declaration of condominium that's been recorded. Well, what happens then? You have a lien, but these are the terms. Let's assume first of all, let's go back. When contracting with a condominium association, the contract is usually for common elements. In other words, Southeast, you may be doing work for the roof, okay, or the hallways, or whatever else may be a